Hi everyone, this is video number 25 of my legal video education series focusing on the good moral character requirement to obtain a law license. The topic is discussed at length in my book titled State Bar Admissions and the Bootlegger's Son, which is available on both of my websites, which are gutmanvaluations.com and heavensadmissions.com. Both websites also contain two other books that I wrote, one of which is a supplement to State Bar Admissions and the Bootlegger's Son, and the other which is a fictional novel which is kind of upbeat and comical, titled Heaven's Admissions Process. It essentially compares the criteria to be admitted into heaven with the criteria to obtain a law license on earth. It's kind of a fun book. I maintain two Facebook pages where my legal education videos are posted. One is my personal page, which is just Evan Gutman. The other is titled Judicial Constructive Criticism Network. I also maintain a YouTube page where the videos are posted, which goes by the same name, Judicial Constructive Criticism Network. For each video, there's a PDF associated with it, which you can obtain by either going to my websites or on Facebook. You can also, there's a direct link to the PDF, which then brings you to both of my websites. YouTube, basically, there's just a link to the websites themselves, but it's listed under videos for the PDFs for the videos. So today, I'm going to address what is known as the judicial function exception. And essentially, what occurs in regards to this is that rather than adopting a fair and objective standard of truthfulness, candor, and honesty for everyone, what the judiciary chooses to do, particularly in the bar admissions process, it adopts an irrational standard for non-attorneys. But, of course, the judiciary itself doesn't want to be subject to such an irrational standard, so it exempts itself from applying that standard to courtroom litigation and the judiciary itself. When a person enters law school, they begin to learn how the legal profession really functions. They are taught as a matter of substance. In substance, what's really occurring is they're taught how to lie when preparing a client's case to the court. In other words, don't present to the court information that's detrimental to your client. Information that is detrimental to your client, try to indicate that it's really not that bad, so downplay it by misleading the jury or misleading the court. And what realistically happens is they come to the understanding that the heart and soul of a lawyer's professional success, the heart and soul of a lawyer's professional success is predicated upon how nimbly they can misrepresent, mislead, contort or hide the facts, law, and evidence, except to the advantage of their client. The art of successful lying, in court requires the lawyer and the judges to repeatedly emphasize the importance of truth. So the concept is that by emphasizing the importance of truth, candor, and honesty, you then basically kind of clear the way for yourself to misrepresent, mislead, and contort the law, facts, and evidence. For instance, if you were to apply the standard of honesty and candor to the judiciary itself, well, then every time there's a dissenting opinion that says the majority is misleading or being dishonest, that would subject either the majority or the dissent, depending upon which one is really right, to punishment for misleading, contorting the facts. And it happens all the time, basically. So what basically they say is, no, in appellate opinions, you get to say the other side lied. You get to say the majority lied, or the majority gets to say the dissent lied. But the other technique that really applies to courtroom tactics and attorneys is known as the judicial function exception. And one of the ways this manifests itself is Federal Statute 18 U.S.C. 1001. 18 U.S.C. 1001, a congressional statute enacted by Congress. It criminalizes the following dishonest conduct. It criminalizes the following dishonest conduct. Quote, whoever shall knowingly and willfully falsify or conceal a material fact in any matter within the jurisdiction of any department or agency of the United States. So in other words, if you willingly falsify or conceal a material fact in any matter within the jurisdiction of a department or agency of the United States, that's criminal conduct, and you can be prosecuted for it. That's how the statute originally read. I'll finish up this video by telling you how it reads today, but I want to bring you to the history of it. The question came whether that statute, which contains language limiting its application to any department or agency of the United States, does that apply to courts? Is the judiciary a department or agency of the United States? This became a hotly contested issue because it essentially was determinative of whether 18 U.S.C. 1001 could be applied to criminalize conduct of dishonest statements a lawyer makes in court. So the U.S. Supreme Court addressed this issue in 1955, and they did so in the case of U.S. v. Bramblett, B-R-A-M-B-L-E-T-T. And in that case, the U.S. Supreme Court, quite correctly in my view, correctly it says, I know I quite often say they're incorrect, but in this instance I think they were correct, they indicated that the statute's reference to department or agency of the United States did in fact apply to the judiciary. In other words, if a lawyer made dishonest statements under U.S. v. Bramblett, it would seem that they could be prosecuted for making those dishonest statements or concealing material facts by a court of law. The problem is, as previously indicated, lawyers are always concealing material facts when they argue cases to the court. So it created what they felt was a problem. The problem being that, are lawyers really supposed to be honest or not? So what happened was 6 or 7 years after that opinion, the U.S. v. Bramblett opinion, in 1962, the Federal Court of Appeals, in the case of Morgan versus United States, a 1962 case, they created what was known as the so-called judicial function exception. And interestingly, the case dealt with an individual who was convicted of violating Section 1001 by holding himself out to practice law, even though he was not an attorney. And so it was a case dealing with the unauthorized practice of law, which, as previously indicated, is the heart and soul of the legal monopoly. What the defendant did in the case was brilliant on his part, absolutely brilliant. The defendant presented the brilliant argument that if his Section 1001 conviction was upheld because he falsely represented he was a lawyer, that would mean it would also be a Section 1001 violation to engage in, quote, traditional trial tactics. In other words, he's saying, if you convict me for this, then you should be convicting every single lawyer who makes a dishonest statement in a court of law under U.S. v. Bramblett. So to evade the defendant Morgan's inescapable logic, in my view, the Court of Appeals in Morgan created the so-called, quote, judicial function exception, unquote. And the Morgan court accomplished this subterfuge, in my view, by writing as follows. We are certain that neither Congress nor the Supreme Court intended the statute to include traditional trial tactics within the statutory terms, quote, conceals or cover up, unquote. So they create an exception basically saying, we're good with this 1001 statute applying to everybody else, but in court, lawyers are allowed to lie because those are just traditional trial tactics. So that stood where it was for quite a long time. The concept being that 1001 applied to everybody, but there was a judicial function exception for lies that lawyers tell in court, if not under oath. If it's under oath, that's perjury. But if it's not under oath, the arguments, if lawyers lie or if judges lie to each other in their appellate opinions, it's considered basically okay and not subject to Section 1001. So what then happened was in 1994, the issue came up again in the case of U.S. v. Hubbard. And in U.S. v. Hubbard, the Federal Court of Appeals for the Sixth Circuit, they demolished the judicial function exception, and they wrote, quote, as follows: "The judicial function exception does not rest on solid legal ground." And then all of a sudden, lawyers were once again potentially subject to being prosecuted if they misled or concealed a material fact in federal court. By the way, these are federal cases. Same type of thing generally applies in state courts, but these were federal. So under the Federal Court of Appeals opinion in Hubbard, at least in the Sixth Circuit, the judicial function exception no longer appeared to provide safe haven for attorneys and judges. As a result, the case went to the U.S. Supreme Court. And what the U.S. Supreme Court did was really interesting. It was very interesting. What the U.S. Supreme Court did is they revisited the Bramlett case. Now, Bramlett had held that the phrase department or agency does in fact include the judiciary branch of government. And that was a U.S. Supreme Court case. But in Hubbard in 1994, the U.S. Supreme Court got around the Sixth Circuit's reasoning about the judicial function exception by saying that the phrase department or agency does not include the judiciary branch of government. So what they did is they kind of went along with the fact that there's no judicial function exception anymore. But the reason there's no judicial function exception is because the entire statute doesn't apply to the judiciary, because the judiciary is not a department or agency of the United States. Thus, what they did is lawyers were still allowed to mislead and lie in court, but not because of a judicial function exception, but rather because the whole statute didn't apply to the judiciary. The final event in this ridiculous story that is just based upon semantic wordplay by the judiciary. The final event was 1 year after the Hubbard decision by the U.S. Supreme Court, approximately 1 year after it. The U.S. Congress amended 18 U.S.C. 1001. And this is where I said the statute's a little different. And they expressly indicated in the statute itself that the phrase department or agency includes the judiciary branch of government. Thus, the judiciary was no longer exempt from 1001, but instead it revived the judicial function exception, which the Sixth Circuit had previously gotten rid of and which the U.S. Supreme Court went along with. The impact being that now the judicial function exception is back in play, and lawyers are allowed to mislead, conceal material facts, at least in federal courts, and most state courts tend to follow the same rationale. And they're allowed to, basically be dishonest. So all these concepts of honesty, candor, and being forthright and having full disclosure, they apply to the average citizen, but they don't apply to the attorneys in court, and they don't apply to the judges. Anyway, I hope you found this interesting. Shows how the legal profession and judiciary work. And we'll have the next video within the next couple days, 3 days, 4 days, 5 days, whatever. And we'll see you then. And remember, love right, don't fight. Bye, everybody.